Good morning, class. Welcome back to Federal and Indian Gaming Law. Today we have a guest speaker, an extraordinarily accomplished Indian law attorney, and among his accomplishments is that he litigated the California versus Cabazon case before the Supreme Court. And with that, I'd like to introduce Glenn Feldman and give him as much time as possible. Glenn, thank you so much for being here. It is truly a treat.
Morning, and thank you, Greg, and thank you to all of you who have gotten up and are in a class at this ungodly hour. I went to law school a long time ago, but I have to tell you, I don't remember any 7:30 a.m. classes. So you all get a lot of credit in my mind for being here this morning. So what we're going to do, spend the next hour or so talking about the Cabazon decision, and I assume you've discussed it to some extent in the class. And you know, I sort of view this as an insider's view. What I want to try to do is give you a little sense of how this case developed, both procedurally and substantively, how the Supreme Court, looked at these issues, both in oral argument and in the final opinion that they issued, and just give you a little bit of sense of how the oral argument went. This is a multimedia presentation. Greg, who's a techie, has embedded the oral argument portion. When I used to do this, I used to have a small cassette tape player, and I used to actually play the cassette tape. Let me tell you in advance, the audio quality isn't great. This is coming from a 35-year-old. It was recorded on a cassette. I mean, the Supreme Court today, there are arguments are recorded digitally, but then they were recorded on little cassettes. And so the audio you're going to hear later is from an old cassette tape, and it's not great. So I'll advise you in advance. You'll need to probably turn up the volume a little bit when we get to the oral argument audio. But in any event, that's the way I hope the morning is going to go. Before we turn to the case, let me give you a little bit of background about the Cabazon Band of Mission Indians. The Cabazon Band, then called the Cabazon Band of Mission Indians. Since then, and much more recently, they have adopted a new constitution, and they are now, their name now is the Cabazon Band of Cahuilla Indians, but at 1986 and 1987, they were a Cabazon Band of Mission Indians. A very small tribe, like many tribes in Southern California, really a grouping of just a few families, never been more than a couple dozen total members. They occupy a reservation of about 1,800 acres in the Coachella Valley, south and east of Palm Springs. It was then, less today, but then a pretty desolate area. There was not much out there. And Palm Springs was a little oasis, but you know, there was not much else out in that area. And the tribe, like most tribes, needed to find ways to generate some tribal revenues. And so they went through a variety of different activities. They started with what they hoped was going to be a jojoba field. Jojoba is a desert plant that produces a little bean or a seed that has an oil in it. And that oil actually has some commercial value. And so in the mid-70s, they got a little grant from some state university in California and planted a jojoba field. But they didn't really know what they were doing, and there was no irrigation, and you know, nobody, you know, it was a failure from the beginning. And so the jojoba field dried up pretty quickly. But then I got involved with the tribe in the late 70s, and their first venture that I was involved with was the sale of cigarettes. Like a lot of tribes around the country, they were trying to generate revenue by selling cigarettes without charging state cigarette taxes, and those taxes are a significant part of the overall price of a pack or a carton of cigarettes. And they did that for a while, but then the Supreme Court stepped in a number of cases back in the late 70s and early 80s, and essentially said that tribes could not sell tax-free cigarettes to non-Indians. And that case actually played a significant role. We'll talk about that in some detail. That cigarette tax case played a significant role in the Cabazon case and the Cabazon decision. So the cigarette outlet was shut down, and they then moved on to what didn't last very long. They tried to sell alcohol through the mail. They had a mail order alcohol business, which they advertised heavily in the National Enquirer. And I don't remember why they picked the National Enquirer as their main advertising source, but they did. And today, I think it's possible to buy alcohol, I think, through the mail. I think, there are wine of the month clubs and things like that. But I can tell you, in the late 70s and early 80s, we quickly learned that there were about 17 different federal statutes and regulations that prohibited the sale of alcohol through the mail. And after we got about a dozen cease and desist letters from the U.S. Attorney and the FBI and postal inspectors, the Cabazon liquor by mail operation shut down pretty quickly. So then they turned to the subject of this discussion this morning. They turned to gambling. And the Cabazons, unlike a lot of tribes who were looking at gambling or gaming at that time, did not initially open a bingo parlor. A lot of tribes did, high stakes bingo. The Cabazons took a different position. They opened a poker room. Now in California, commercial poker has been legal forever. I think it has its origins during the gold rush days, but the playing of poker has never been outlawed in the state of California. And in 1980, there were roughly 450 commercial poker rooms scattered around California. It was essentially a local option situation where there was no state law against it, but local governments, cities and counties, could authorize it, regulate it, prohibit it. It was basically up to the local government. So at this point, desperately looking for a source of revenue, the Cabazons said, wait a minute, we're the local government on the reservation. If the city down the road or the county across the way can determine whether they want poker, we're the local government on the reservation, we can make the same decision. So they passed a tribal ordinance authorizing and regulating and taxing poker on the reservation, and opened in the fall of 1980, opened their poker room. Greg, next slide, please. So let's talk about the timeline of the case. This is pretty interesting, at least from a procedural point of view. And I think the takeaway from this part of the discussion is litigation takes a long time and takes twists and turns that you can't anticipate at the outset. So the Cabazons opened their poker room in the fall of 1980. The poker room was nothing elaborate. It was the same double wide trailer that had served as their cigarette sales outlet and their liquor warehouse. But now it was a card room, and they brought in a few poker tables and some chairs, and they had chips and a coffee pot in the back corner, nothing elaborate, and opened in the fall of 1980. Well, within a few days of opening, the city of Indio sent a SWAT team crawling across the desert. And I'm being serious. I mean, they sent about a dozen officers decked out in flak jackets and Kevlar helmets and carrying AK-47s, crawling across the desert, and showed up one night and shut the place down. They cited, there were probably a dozen customers and a half dozen tribal members in there. Everybody was cited for illegal gaming because the city of Indio had a ordinance that prohibited poker. They said, well, you're within our city limits. We don't care about your tribal ordinance. You're violating our ordinance. And they cited everyone, seized the chairs, the tables, the cash, the chips, and closed the place down. Within a day or two, we were in federal court, Central District, California, in downtown Los Angeles, filing what was then called Cabazon Band versus City of Indio. Now, the tribe opening the card room was no secret. This was not something they were doing in the dead of night. They had announced in advance what they were doing and why they thought they had the right to do it. And at the same time, the city told us that they didn't think they had the right to do it and they intended to take action. So I don't remember for sure, but I suspect that I probably had the complaint drafted before they opened the door. And so, the morning after the raid and the closure, I was on a plane to Los Angeles, filed the lawsuit, and at least initially seeking a temporary restraining order. So I walked into federal court that morning. I was much younger at that point, all dressed up, suit, tie, looked very professional, and proceeded to tell the judge why the city of Indio had no jurisdiction to enforce its ordinance on the reservation, and why the tribe, as a government, had sovereign powers and had the same authority that any other local government would have, and why, under principles of tribal sovereignty and self-government, we ought to win. Now, the judge at that time, the judge we were before, was not a new judge. He'd been on the bench a long time, but I'm pretty sure that this was the first Indian law case he had ever heard. And so when I walked in and started spouting principles of Indian law, I could tell very quickly his eyes glazed over. He had no idea what I was talking about. I'm not sure. He thought I had dropped in from some other planet, and he very quickly denied the TRO. So the facility remained closed. 10 days, but here's what, I'm telling you, you can't predict things. 10 days later, I walked back in seeking a preliminary injunction. And by then, I think he must have told his clerks, this guy's probably out of his mind, but do a little research and see if there's anything to what he's talking, what this Feldman guy is talking about. And lo and behold, 10 days later, he grants our preliminary injunction and orders the city to return the cards, the chips, the cash, and the Cabazons are back in business. And they stay in business through the district court proceedings. There was no trial. The case was decided on cross motions for summary judgment based on stipulated facts. But in May of 1981, after a lot of briefing and argument and things, the court rules against us. He denied the TRO, granted the preliminary injunction, and then 18 months later rules against us on the merits. But I went back in front of him a day or two later and asked him, this is a fairly unusual procedural motion, but we asked for an injunction pending appeal. And we're basically saying to the judge, you just ruled against us on the merits, but we're asking you to allow us to continue to operate as if we had won while we appeal the case up to the Ninth Circuit. And to everybody's surprise, he grants that motion. Now, I think he was persuaded by the fact that we had demonstrated that the card room was the tribe's only source of tribal revenue at that time. And I think he must have felt that it was at least a close question, and so granted us an injunction pending appeal, so we were able to remain open during that appeal process. And we immediately went to the Ninth Circuit, and in December of 1982, the Ninth Circuit reverses. But they reverse on grounds that are not very helpful to us. What had happened is this. In the early 70s, the city of Indio had made an effort to annex the land, the Cabazon reservation land. And California had a process under state law where a local government could try to annex federally owned land, but it had a lot of requirements, and it certainly required the federal government to consent to that annexation. In this case, the city had ignored all these state laws. They had just passed the city council passed a resolution saying, we hereby annex the following described land, which was the reservation. And we were able to point out in this litigation that that was invalid. That wasn't the way you annex federal land. And so the Ninth Circuit ruled in our favor, but only on the annexation question. They said, wait a minute, city of Indio, your annexation was invalid. You have no jurisdiction over this territory. Next slide, please. So we breathe a sigh of relief, but only for a couple of months. 2 months later, Riverside County comes knocking. Riverside County says, well, you may not be in the city of Indio, but you are certainly within Riverside County, and we have the same anti-poker ordinance that the city of Indio has. So it's like deja vu all over again. They send a SWAT team out, the helmets, the jackets, the AK-47s, cite the players and the tribal members for violation of the county, in this case, the county ordinance. We are back in court within a day or two in front of the same judge, who had ruled against us in 1981. But by February of '83, there was case law that had developed around the country, and we'll talk about that in a minute. And so, based on the case law that had developed, the court, same judge, granted us a TRO, granted us a preliminary injunction, and again, we stayed in business throughout the litigation. In December of 1983, while we're still in the district court, the state of California intervened in the case. I think by that time, there were things going on around the country and in California, and the state realized that this was not just a matter of local interest. There was some significant state interests involved in this case. And so they intervened. And at that point, the state of California really took over the litigation from that side. Even though the county had been the initial defendant, the state became the principal actor here. Second thing that happened at this time is our case, the Cabazon case, was consolidated with a similar case that had been filed by the Morongo Band of Mission Indians, another Southern California tribe that had opened a bingo parlor, high stakes bingo parlor, and were involved in litigation very similar to ours against the county. And so our cases were consolidated at that point. And by then, I should mention, the Cabazons had also opened a high stakes bingo parlor. So they were operating both bingo and poker. Next slide, please. So in December of 1984, the district court rules in favor of the tribe. By then, the judge, who had been waffling on these issues over the early years of the litigation, I think had realized that, I wasn't completely nuts, and that at least some of the things I was saying had some merit, and rules in our favor on the merits. That case gets appealed up to the Ninth Circuit. In February of 1986, the Ninth Circuit affirms. And that's a published opinion. It's worth reading. I mean, it was an early circuit court decision on these issues, and it was a decision that still gets cited from time to time because there's some good language in there about tribal authority over their reservations. Next slide, please. So we've won in the Ninth Circuit on the right issues. I should mention, this was the case against the county with the state intervening. Now, the only issue are the Indian law issues. The annexation issue is long gone. We're now talking about the real issues in the case. The Ninth Circuit affirms on those issues. In April of 1986, the state and the county seek Supreme Court review of that decision. And in June of 1986, the court agrees to hear the case. Not good news from our point of view, obviously. We've won in the court below. We'd be very happy if the Supreme Court kept their hands off this case, but that wasn't to be. Just as an aside, I got this news. This was pre-internet and pre-cell phones. I got the news that the court had agreed to hear the case on a payphone in a gas station in Amarillo, Texas. At that point, in June of '86, my family and I were moving from Washington, D.C. to Phoenix, where I am today and have been since then. And I stopped at a gas station to get gas, called my secretary on a payphone, and she told me that the court had issued an order agreeing to hear the Cabazon case. So it was not good news from our point of view. In December of '86, we argued the case before the court, and in February of '87, the Supreme Court affirms the Ninth Circuit in a 6-3 ruling. Next slide, please. So the Cabazon case did not arise in a vacuum. As I said, while we were litigating through the district court twice and the Ninth Circuit twice, other courts and other tribes had been addressing similar issues around the country. And so we had a bit of authority that had developed during this time, most of which was very helpful to us. Not on this slide, but key to the case was a 1976 Supreme Court decision called Bryan versus Itasca County. And I don't know if you've discussed that in your class or not. Bryan was a tax case. Case arose out of Minnesota. The state of Minnesota attempted to impose some taxes on some tribally owned property on the reservation. And and this was in a PL 280 state. Greg, have you talked about PL 280?
We did. We briefly went over that.
Okay. All right. So you know the PL 280 is a 1953 congressional act by which Congress gave 6 or 7 named designated states certain measure of civil and criminal jurisdiction over Indian country within those states. But in Bryan versus Tasca County, the court sort of analyzed that and told us what PL 280 actually meant. And what it told us was that as far as criminal jurisdiction was concerned, PL 280 gave those states full criminal jurisdiction over activities on the reservation, and state criminal laws applied on the reservation to the same extent they did elsewhere. But with respect to civil jurisdiction, the court made it clear that the measure of jurisdiction given to the states under PL 280 was much narrower, much more narrow, much more restrained. And basically the court said that PL 280 does not give the states full civil regulatory jurisdiction over tribes and tribal activities. That while criminal prohibitory actions enactments do apply, civil regulatory state laws do not. And so that distinction became critically important to the outcome of the Cabazon case. And it was also employed in these other cases up on the screen. So in 81, we have the Oneidas in Wisconsin with a bingo parlor, the district court concluding that the state's bingo laws were civil regulatory and therefore not applicable on the reservation. Although she said in her opinion, I'm deeply troubled by having to reach this conclusion. She was no fan of what she was doing, but to her credit, she ruled the right way. Seminole versus Butterworth, case out of Florida, again, high stakes bingo. Fifth Circuit holds for the tribe, but in a 2-to-1 decision. And one of the judges offered a very strong dissent, arguing that no, the state law should apply on the reservation. And then by 1982, a year later, we have the Ninth Circuit issuing its decision in Barona versus Duffy, a case very similar to the Cabazon case. It involved high stakes bingo in California, and the Ninth Circuit panel rules for the tribe, again on PL 280 grounds, finding that the state's laws were civil regulatory and the tribal interests outweighed those of the state. So we've got a bit of authority developing as our case moves forward. Greg, next slide. So why did the court grant cert in the Cabazon case in 1986 when it had denied cert in both the Butterworth and the Barona cases in the early 80s? And I think the answer is the court was paying some attention to what was going on the ground. So in the early 80s, there were only a handful of tribal gaming facilities around the country. We're not sure the exact number, but it was certainly less than a dozen. So when those cases went up to the Supreme Court, I think the court said, well, wait a minute, these are not matters we need to dirty our hands with. This is probably going to disappear. We're not going to get involved in this Indian gaming stuff. But by 1985, it had exploded. There are 100 operations and more than 25 in California alone. So I think the court, they used to say the Supreme Court justices read the papers. Today they would say they surf the web, I suppose, or something. But in any event, the court, I think by the mid 80s, realized this was not going away, and that this case presented them with the opportunity to provide their views on tribal gaming. Next slide, please. So we get to the briefing stages of the case, and the state went forward with had in their quiver a variety of pretty good authorities on which they could rely. And I describe this as the trilogy of sin. So we have Washington versus Colville. These are the cigarette tax cases that I was talking about before, or at least one of them. And in this case, the court had ruled that the tribe, the Colville tribes, could not sell tax-free cigarettes to non-Indians on the reservation. What they said was that all the tribe was doing was marketing an exemption from state tax laws. Marketing an exemption from state tax laws, and no reservation value was being added to the transaction. The tribe was just importing cigarettes from a distributor, not collecting state tax, selling them to non-Indians who drove onto the reservation for the sole purpose of buying cheap cigarettes. And the people would buy the cigarettes and then drive away, leave the reservation. So state says, tribe's not offering any reservation value, they're marketing exemption. Tribe, you have no authority to sell these cigarettes without collecting state taxes. The state says, your honors, this is our case. Just substitute gambling for cigarette sales. This is exactly what we're dealing with here. It's a very simple matter. They also relied on Rice versus Rayner, 1983 Supreme Court decision. There was federal legislation, and it still is today, saying that if tribes want to sell liquor on the reservation, they have to do a couple of things. Among them is pass a tribal ordinance authorizing it and get the BIA to approve that ordinance. But it also says they have to comply with applicable state laws. And in Rice versus Rayner, the court held that those applicable state laws included getting a state liquor license. So again, the state's position is, well, if state liquor laws apply, then why don't state gambling laws apply? Again, very simple resolution. Finally, we have United States versus Dakota. This case was a Sixth Circuit case decided while we're briefing our case. This was a federal gambling prosecution. Unlike our cases where we're opposed by the state, this was one where a tribal member in one of the Sioux reservations, I'm not sure where, had put a couple of slot machines in the garage of his house and opened what he called his own casino. Well, not surprisingly, the feds moved in and arrested the guy and were prosecuting him under the Organized Crime Control Act, among other things. He said, well, wait a minute, we need to analyze this civil regulatory versus criminal prohibitory distinction. That's been applied in all these other tribal gaming cases. And the Fed said, no, this is a federal prosecution. That may have something to do where the states are involved, but this is the federal government. You're violating a federal law. Civil regulatory versus criminal prohibitory doesn't apply. And here again, the state said, well, that's the model that that should apply in our case. Next slide, please. So we're in the process of briefing in the fall of 1986. And by this time, I think both the states and Indian country had recognized that this was going to be a pretty significant case. So during the briefing stage, 27 states filed 4 amicus briefs supporting the state of California. But to their credit, we had 66 tribes. Think of that, 66 tribes filed 8 amicus briefs supporting the Cabazon and Morongo bans. So a lot of outsiders weighing in on this issue. But the question is always, does the Supreme Court even read the amicus briefs? We never know. Occasionally they get cited an opinion, and in that case they did read it. Whether any of these briefs had any bearing, we'll never know, but we certainly appreciated the support that Indian country provided us. Another interesting little factoid here. Ordinarily, in Indian law cases that get to the Supreme Court, if the United States is not a party to that case, the court will almost always ask the Solicitor General, who is the person in the U.S. Justice Department who appears before the Supreme Court, who argues before the Supreme Court. Supreme Court will ask the Solicitor General to provide the court with what they call the views of the United States on this case. They want to know, what does the federal government, you're not a federal government, you're not a party to this case, but tell us what you think of this case. Tell us how you would analyze it. Almost always they make that request. For some reason, they did not do it in our case. And we'll never know why. It was very unusual. But we do know a little bit of the backstory here that's come out since the decision. What we've learned is that the Solicitor General did convene some meetings of high federal officials to discuss this case. And what he learned very quickly was that there was a significant split, a significant disagreement within the federal government. The Justice Department, and primarily the criminal division of the Justice Department, was very much opposed to tribal gaming and felt very strongly that the federal government should support the state of California. On the other hand, the Justice Department and the BIA took the opposite position and felt that the tribes were within their rights and that the federal government ought to support the tribes in this case. So the Solicitor General was never put to the, was never required by the Supreme Court to advance any arguments. And I think he was grateful that he did not have to go to the court and tell them about this dramatic split within the federal government. Next slide, please. So here they are, the Supremes, a very different looking court than we have today. In the back row right is Justice Scalia. Justice Scalia, who I'm sure many of you are familiar with. This was his first term on the court. He had been appointed just a few months earlier, and so these were among the first arguments, or this was among the first arguments that he was involved in. And you'll hear later, he even in his first term on the court, a very aggressive questioner. He left no doubt about where he stood on these issues. The other thing I want to point out is what you've got here is really a bunch of old white guys. And I have nothing against old white guys, trust me, but it's a very different court than what we had today. Lower first row on the left is Justice Marshall, who at that time, with Justice Brennan sitting next to him, were real advocates for tribal sovereignty. They were champions of tribal interests on the court in a way that we don't have today, or may not have today. And they were important parts of of this argument. Next slide, Greg. So argument is December of 1986, and as is often the case, the litigants have very different views about the issues and how the court should analyze those issues. So the state's position is pretty straightforward. Their argument is, this is the Colville case all over again. The tribes are doing nothing here but marketing exemption from state law, no reservation value added. This case should be decided the same way Colville had been decided a few years earlier. They also spoke to a great extent about the fact there was no federal law, no federal regulation of tribal gaming. How can we allow these tribes to operate these things without some federal or state involvement here? And then third, and this is an interesting one, the threat of organized crime infiltration. Now, sitting here 35 years later, that probably sounds a little strange. But in 1986, this was a very real issue. And the state's position was very clear that if you allow these tribes to operate gaming activities on their reservations without state oversight, that as sure as night follows day, they are going to be taken over by the mafia, by La Cosa Nostra from New Jersey and Chicago, and you're going to have nothing but illegal underworld gambling across the country on these reservations. So this threat of organized crime infiltration was a major issue that the state pressed. And we'll talk about that in a minute. We saw the case very differently, as you might expect. In our view, this was Bryan versus Itasca County all over again. Our position was that the state's gaming laws, those laws, state and county laws that regulated or dealt with bingo and poker, were civil regulatory laws. And under Bryan versus Itasca County, they were not applicable on the reservations, that they fell outside of the scope of PL 280. We also argued that the state and county efforts here were preempted by federal law and policy, and that there was infringement on tribal self-government if the state were to be allowed to regulate or prohibit these activities. So let me talk a minute about this preemption argument, because it's pretty interesting. At least at that time, I haven't followed this all that carefully in the years since, but at least at that time, federal preemption in the Indian law context was somewhat different than preemption in other federal law contexts. You didn't need quite as much express intent by Congress for the court to find that federal law and policy preempted state law in the Indian law context. And while the state was right, there was no specific federal law that authorized or regulated Indian gaming. We were able to weave together a web of related events and related facts that I think persuaded the court on the preemption argument. And what were those facts? Well, there was no specific federal Indian gaming statute, but there were other federal laws that had been passed in previous years, including the Indian Self-Determination Act and the Indian Financing Act, both of which made it explicitly clear that the federal government's policy was to promote tribal self-government and the development of strong reservation economies through economic development activities. So they didn't mention gaming in particular, but our position was this is exactly what we're doing. We're strengthening tribal government, providing economic development opportunities through gaming activities. In 1983, President Reagan had issued what he called his Indian policy statement. And the Indian policy statement said, the federal government can no longer continue to finance all these tribal activities, provide all these grants and other benefits to tribes. Tribes need to go out and find innovative new ways to finance their own activities. Well, here we are. We're trying to use innovative activities to finance tribal government. But it wasn't just us saying it. We actually went to the BIA and got a couple of high BIA officials to provide us with affidavits in which they said it is the position of the BIA and the Department of the Interior that the Reagan policy statement applies to tribal gaming. That's exactly what President Reagan had in mind, that these tribes are doing exactly what the president has required and requested them to do. And those affidavits turned out to be pretty important. We'll talk about that in a minute. But let me make one other point here, and that is litigation requires you to develop a record, and it requires you to anticipate things that may not seem critically important at the time, but can turn out to be. And I can tell you, those affidavits, which were not exactly an afterthought, but we weren't sure how effective they were going to be. Those affidavits that we got from these BIA guys turned out to be very important and were an important part of the record that the Supreme Court looked to. So again, part of the argument that there was federal preemption here, the federal government had already occupied the field here. And then the last thing that we argued in this instance was this. The Mashantucket Pequots from Connecticut had also had a case that had worked its way up through the lower courts. And in that case, the Pequots had actually gotten some agency of the federal government, I think it was HUD, Housing and Urban Development, to provide financing for their tribal bingo parlor. And we were able to get that into the record. So here again, federal involvement, federal preemption. Well, here the feds are actually providing financial support to a tribal gaming facility. And all those things together, mixed together, enabled us to develop a pretty effective argument that the federal law preempted any effort by the states to prohibit or regulate tribal gaming. And again, based a lot on the record that had been developed early on, when it wasn't entirely clear how important some of these facts were going to be. But it turned out to be very important. Next slide. So we argue in December and on February 25th of 1987, and I should point out to you that was just almost exactly 35 years ago, the court issues its decision, a 6-3 decision. Next slide. And the headlines tell the story. So now we turn to the famed multimedia part of the presentation. Next slide, Greg. And we're going to talk about what the major issues were as presented to the court and how they addressed them both at oral argument and in their decision. So let's hope this works. The first issue is, as I told you earlier, this threat of organized crime infiltration. Seems a little silly today, but the court took out on this issue and began asking about it very early in the oral argument. Let's see if I can do this. Greg, I think you're going to have to do it.
I'll just ask this question. You mentioned, and your brief also mentions, organized crime and the danger of infiltration. Is there any evidence that organized crime has infiltrated the bingo operations of the tribes that are before us? Any evidence in this record?
Not in the record, not in the record. But if to fully answer your question,
this is the lawyer for the state.
I would have to go outside the record, and I'm reluctant to do that.
I'll withdraw the question. Then you argue in your brief that is a concern of the state of California.
Yes. The possibility that the bingo operations may be taken over by organized crime is a very serious concern to the state of California. We did, by the way, indeed concede below that we do not allege, quote, we do not allege the existence of organized crime in this case. We have never conceded that organized crime may or may not be involved in this case. But our view is that California law is intended to prevent organized criminal infiltration before it takes place, rather than simply eradicate a criminal operation after it has actually occurred.
So what he said there, wait, don't do this yet. What he said there was pretty important. And again, the development of the record. As I mentioned, in the lower courts, these cases were decided on cross motions for summary judgment based on a stipulated set of facts. And that's often true in Indian law cases. The facts are often not at issue. It's really the law and how you apply the law. So we had stipulated facts, and we had somehow, and I don't remember the details at this point, we had somehow gotten, I think it was the county, to agree down in the district court in these stipulated facts that they were not alleging that there was any organized crime infiltration of the Cabazon or Morongo operations. So the stipulated facts in this case are, we're not alleging that there's any organized crime. Yet by the time they get to the Supreme Court, they're telling the court that this is a very real concern of the state. There's a little bit of a dichotomy there. So I was quick to point out in my argument that they had not alleged this, but there was some discussion about what that really meant. So Greg, next.
Let me turn for a moment to this question of organized crime. What we're dealing here on the part of the state of California is at most a hypothetical concern. They've stipulated to the fact that there is no organized crime involvement on either the Cabazon or Morongo reservation. Now, they draw some distinction between whether they are alleging that it is or isn't.
I didn't understand them to stipulate that there wasn't any. They just said they haven't alleged any to be there.
Well, they said they hadn't alleged it. My question is, if I was representing the state and I knew of some, I don't think I would keep it a secret. I think I would get it out before the court.
They say there's a real danger. That's what they say.
They say there's a real danger, but the evidence points directly in the opposite direction. The Ninth Circuit concluded that there was no evidence of organized crime.
So we have this discussion about organized crime, and the court then says the following. It says the state insists. I'm reading now from the opinion. The state insists that high stakes offered at tribal games are attractive to organized crime, whereas the controlled games authorized under California law are not. This is bingo, where the state allowed bingo, but limited the size of prizes to $250. The tribes were offering prizes significantly higher than $250. So the court says this is surely this organized crime concern. This is surely a legitimate concern, but we are unconvinced that it is sufficient to escape the preemptive force of federal and tribal interests apparent in this case. The preemptive force, remember what we were just talking about. California does not allege any present criminal involvement in the Cabazon and Morongo enterprises, and the Ninth Circuit discerned none. Sounded a lot like the argument. Next slide, please. So the court concludes, we conclude state's interest in preventing the infiltration of tribal bingo enterprises by organized crime does not justify state regulation of the tribal bingo enterprises in light of the compelling federal and tribal interests supporting them. State regulation would impermissibly infringe on tribal government. So again, we've got these ideas of preemption and infringement making their way into the court's opinion. So apparently the court found our arguments on that point persuasive. Next slide, please. So then we go to the Colville analogy. And this was, I think, really the state's strongest argument. You know, as I said, their position is this is just the Colville case. No reservation value. They're simply marketing an exemption here. And Justice O'Connor asked me about this very early in my argument. Greg, next.
Mr. Feldman, I guess the most obvious concern about your position in the case is the concern we would have that the tribes are marketing an exemption from state law, and the analogy to the cigarette tax situation, as in Colville.
Well, Your Honor, we think the situation here is considerably different than that presented in Colville. I would note at the outset that in the cigarette tax case, that the incidence of the tax at issue there was on non-Indians. In this case, the incidence of the state's jurisdictional scheme is directly on the tribes themselves. So the question of whether the state has jurisdiction to regulate these activities is a considerably different one. Getting back to the question of marketing and exemption, the key element there, I think, was that the tribes were not providing what was called value generated on the reservation. Here, the situation is quite different. There you had people coming out of the reservation, buying cigarettes which had been imported from elsewhere, and then taking the cigarettes off and evading the obligation to pay state tax. What the tribes are offering here are recreational services, plain and simple.
So what the tribes are offering are recreational services, plain and simple. Well, Justice Rehnquist, who was the Chief Justice at that time, didn't necessarily agree with me. And he then asked me, well, if that's all that's going on here, why do people get in their cars and drive long distances to these tribal facilities, bypassing closer bingo halls at the local Catholic church or VFW hall? And we had this exchange. Greg, next.
Bingo players don't require very much. Bingo players want a chair with a little padding and smoke eaters that will clear the air and get the cigarette smoke out. And if you can provide that better than the guy down the street, then you are going to attract more people to your bingo. I'm being serious. That's what these games are offering. The tribes have built large, modern, clean, well-lit facilities, and they provide a chance for No, this is my argument. But what we're providing are recreational services here, and there's no indication why people go to one bingo as opposed to the other. But the creature comforts certainly have something to do with it.
I'm not sure who the justice was, but what the justice asked me was, is this a commercial for your client? And I said, no, this is actually my argument. But so we have this discussion about marketing exemption and reservation value. And again, let me read from the opinion. The court says the tribal customers do not simply drive onto the reservation, make purchases, and depart, but spend extended periods of time there, enjoying the services the tribes provide. The tribes have a strong incentive to provide comfortable, clean, and attractive facilities and well-run games in order to increase attendance at the games. Next slide, please.
Mr. Feldman, I guess the most obvious.
And they concluded by saying, here, however, the tribes are not merely importing a product onto the reservation for immediate resale to non-Indians. They built modern facilities and provide recreational activities, recreational opportunities and ancillary services to their patrons. The Cabazon and Morongo bands are generating value on the reservation through activities in which they have a substantial interest. So here again, we've convinced the court that this is not Colville all over again. We've convinced them that these are dramatically different circumstances and situations. Next slide. So now we get to our principal argument, Bryan versus Itasca County. This was really the crux of our argument. We could not win this case if we couldn't convince the court that the state and county laws at issue here were civil regulatory under the Bryan analysis and not criminal prohibitory. And that was our argument, or the thrust of our argument. But as you'll hear from this exchange, Justice Scalia was not buying that argument. I had not done a very good job of convincing Scalia, at least, of the wisdom of my thinking. So, Greg, let's play this.
I mean, why is the difference between roulette wheels and bingo cards more significant as to whether it constitutes a prohibition as opposed to merely a regulation than the difference between bingo for under $250 and bingo for $1 million?
Well, the difference
that's more important. That distinction is more important. In other words, I'm asking, are you sure that this is just a regulation and not a prohibition? California prohibits bingo for more than $250, just like prohibiting roulette wheels.
California permits but regulates the playing of bingo.
Not for over $250.
Well, the question is, are you focusing on the penal sanction, or are you focusing on the total regulatory scheme?
So focusing on the activity. Why isn't it realistic here, in light of the interest involved, to consider the activity bingo for more than $250? And that is absolutely prohibited in California.
Well,
I think California is prohibiting high-stakes bingo. And
California,
offering high-stakes
the question becomes this: does the inclusion of a penal sanction in their regulatory scheme give them jurisdiction over these tribal activities? That's the question you're asking. If the inclusion of that penal sanction, which establishes the outside limit of their regulatory scheme, does that give them jurisdiction? Our answer to that under Bryan is absolutely not. If that were the law, Bryan would be gutted. Bryan says states were not authorized to exercise general regulatory jurisdiction over
All Bryan held was that a tax statute couldn't be applied in Itasca County.
Well, that was the issue, but the court used the phrase civil regulatory jurisdiction, including taxation, 4 times.
So that last comment came from the Chief Justice Rehnquist, and Justice Rehnquist was no friend of Indian tribes during his tenure on the court. And what he was trying to do there, pretty obvious, he was trying to limit the scope of Bryan. He was saying, well, that's just a minor tax case. That has nothing to do with what we're talking about here. That was just, they held the taxes couldn't be applied there. But as I pointed out to him, that was the subject of the case. It was a tax case, but the court's ruling was, the language that the court used was significantly broader than that. And at the end of the day, in their opinion, the court said the following. In Bryan versus Itasca County, we interpreted Section 4 to grant states jurisdiction over private civil litigation involving reservation Indians in state court, but not to grant general civil regulatory authority. The act plainly was not intended to affect total assimilation of Indian tribes into mainstream American society. We recognize that a grant to states of general civil regulatory power over Indian reservations would result in the destruction of tribal institutions and values. Next slide, please. And the court concluded by saying, we are persuaded that the prohibitory regulatory distinction is consistent with Bryan's construction of PL 280. In light of, and this sentence gets quoted a lot from Cabazon, in light of the fact that California permits a substantial amount of gambling activity, including bingo, and actually promotes gambling through its state lottery, we must conclude that California regulates rather than prohibits gambling in general and bingo in particular. So here again, the court is persuaded. Court is persuaded that the Bryan distinction applies here. Next slide, please. The last issue I want to talk about is the absence of federal legislation. Again, this was a major issue the state presented. And it is true that there was no federal Indian gambling legislation on the books in 1986 when this case was argued. But Congress had been considering such legislation for 3 or 4 years. As early as 1983, some bills had been introduced in Congress that would have either regulated or prohibited or done something with respect to Indian gaming. There were a lot of different bills and a lot of different views on this. So there was legislation out there, and some of it would have authorized tribes to do exactly what Cabazon and Morongo were doing. And that issue was a subject of discussion between one of the justices and the lawyer for the state. So, Greg, next.
And being in the Congress now that would federal legislation that would authorize these games and regulate them too?
Well, there was an Indian bingo bill or an Indian gambling bill that passed the House and then passed a Senate Select Committee. But it was not approved on the floor of the House, and as far as we understand,
to the end of the session, wasn't
it? Yes, but there was more to it than that. I understand that there was a strong opposition on the floor of the Senate to the bill, and also...
Would that bill have authorized the tribes to conduct these games?
Yes, it would have.
And also have regulated how they conduct them?
Yes, it would have provided both for authorization and for regulation.
That's a pretty significant admission by the state's lawyer that there's legislation that's passed the House and passed the Senate committee that would have authorized exactly what the tribes were doing. Now, in fact, Congress had adjourned before that legislation could be enacted. But in my argument, I wanted to make it clear to the court that we expected that legislation to be reintroduced. So, Greg, next.
Well, for whatever reason, it didn't pass.
It did not pass, that's correct. Our belief is, based on some information, that the legislation is going to be reintroduced immediately upon Congress coming back into session, and we have some reason to think that it will perhaps be more successful this time.
Next slide, please. Well, that exchange, I think, satisfied the majority, but the dissenters were
Wrong way.
Yeah. So the dissenters were not persuaded, and a significant part of the dissent in this case by Stevens, O'Connor, and Scalia was that there was no federal legislation authorizing the activities the tribes were engaged in. And I won't read all this, but I mean, just the first sentence, in a sense, unless and until Congress exempts Indian managed gambling from state law and subjects it to federal supervision, I believe that a state may enforce its laws prohibiting high stakes gaming. So the lack of federal legislation was a significant factor to the dissenters here. Fortunately, it only 3 of them held that view, but it was a significant part of their dissent. Next slide. So this is the last part of the argument I want you to hear. It has to do with, well, you can hear Justice O'Connor ask me a question during the argument.
Do you think the tribes could open casino gambling on the reservation?
The answer to that is clearly no. Under 15 U.S.C. section 1175, the use or possession of certain mechanical gambling devices is a federal offense. That relates primarily to slot machines, roulette wheels, wheels of fortune. So in no instance could those activities take place on an Indian reservation. They would be immediately in violation of federal law.
So in December of 1986, I'm telling Justice O'Connor that in no case could there be casinos on reservations because federal law prohibits it. And that was true. I was not lying. Next slide, please. But Congress fixed that problem a year and a half later in 1986 with the enactment of the Indian Gaming Regulatory Act. I won't go through this. I want to leave some time for questions, so I'm going to kind of skip through these last slides pretty quickly. This is just sort of a history. As I said, as early as 1983, Indian gaming legislation had been introduced in Congress. None of these bills had gone anywhere. There were dramatically different bills being introduced, some which would have allowed tribes to basically do whatever they want without any regulation or supervision, others absolutely prohibiting any form of tribal gaming on reservations. And there were a lot of discussion during 83, 84, up until 86, when the court agreed to hear the Cabazon case. At that point, all the negotiations stopped. I think all the people in Congress felt, let's see what the court does before we invest any more time in this Indian gaming legislation business. Next slide. But after the court decision came down in February of 1987, that sort of focused everybody's attention to the issue again. Negotiations took place over a period of about 6 or 8 months, or a little longer. And by the summer of 1988, a compromise had been reached among all the parties. The House and Senate passed the bill in September of 88, and President Reagan signs it in October of 1988. And that, of course, is the Indian Gaming Regulatory Act. Next slide. You've probably discussed this, and I don't want to spend any more time on it. Next slide. You understand the Indian Gaming Regulatory Act, what it did, what it requires. It's still in effect today, obviously. And my view, people ask me what's my view of it. My view is this, that it was clearly, it clearly limited some of the rights that tribes had gained under the Cabazon decision. It clearly cut back on some of the authority tribes would have had, but it was a reasonable compromise. I mean, at that time we were facing people like Senator Reed from your home state, who was advocating as strongly as he could that there should be no tribal gaming. The Nevada gaming industry was the strongest opponent of tribal gaming for many years. So, and they didn't give up even after the Cabazon decision. They were still arguing pretty forcefully against tribal gaming. So by 1988, the compromise that was incorporated into IGRA was accepted. It has worked reasonably well. I mean, there are clearly some problems with it. Not every tribe has been able to get the benefits that it was intended to provide. But my general view is it's worked reasonably well, and for most tribes, it has provided a framework that's allowed them to benefit to a pretty significant extent. Next slide, Greg. And you can see here the benefits. I mean, there are a lot of benefits, but the primary benefit is Indian gaming has pumped billions of dollars into Indian country over the years. These are dollars that weren't there before. These are dollars being generated on the reservation, and you can see the increase there from 95, where you're at five. These are billion with a B, $5.5 billion, to 2019, where you're at $36 billion being pumped into Indian country. Now that number came down a bit in 2020 due to the pandemic, but I think in 2021 and 2022, everything I'm hearing is that the numbers are going back up again. And so I don't think we've seen the numbers for 2021 yet, but my guess is they are going to show a continuation of that trend, of that upward trend. So I think that's one of the principal benefits that both the Cabazon decision and the resulting legislation have provided Indian country. Next slide. Oh, that's it. Who's that handsome devil? All right. I think we have a few minutes for questions. So is that right, Greg? Do we have a little bit of time?
Yeah, we have a little time for questions. So it's a good time for class members to start asking questions. Any questions? Oh, Alex.
Yes. First of all, thank you for the presentation. It was really enjoyable to listen to and learn a bit more about this case. I had a question, just I guess, in terms of you talked a little bit about like the context in which you found out that the case was going to the Supreme Court. I guess, were you all anticipating that it would get there, or was it really a surprise? I know you said like it wasn't necessarily favorable at first that it did go there, but were you anticipating that they would grant cert at this time?
No, we were not, for two reasons. Number one, the court only hears a very small percentage of cases that are presented to it. I think it's 1 or 2%. So just mathematically, you never expect the court to hear the case. And as I mentioned earlier, the court had turned down cert petitions on two other Indian gaming cases within a few years before ours. So, we were hoping they wouldn't. We didn't expect they would. But as I indicated in the presentation, the facts in 1986 were a lot different than they had been in 81 and 82. So I understood why they did it, but we were a bit surprised when they took the case. We were really hoping that they were going to take a pass on this one and maybe decide another one down the road a few years from now.
Courtney.
Sort of going along with that, I have actually two questions. First, did the makeup of the court change? I know Justice Scalia had just come on, but I'm wondering if maybe the members of the court changed and that also like helped the direction they were going in change. And then I'm also curious just how you went about preparing for your appearance before the court.
Well, appearance before the court is nerve-wracking, at least. I'll tell you this. I did not do any moot courts. I mean, today, I don't think anybody appears before the Supreme Court without doing 3 or 4 rigorous moot court presentations. And there are institutions around. I know Georgetown University has a Supreme Court moot program where they provide moot court opportunities for litigants appearing before the court for the first time. I didn't do that. I just felt, it's just a personal thing. I certainly went over my argument many, many times and felt that I was well prepared when I stood up there. Of course, when you stand up there and they call your name and you walk up to the podium, your mind kind of goes blank. It's a pretty daunting experience. But I had, not done a moot court, but I had prepared as well as I could have, and I thought was as well prepared as I needed to be. In terms of the makeup of the court, well, yeah, there's an interesting point there. Let me tell you something. I mentioned Justice Rehnquist, the Chief Justice, who was no friend of Indian tribes and ruled against tribes at every chance he got. He was in the majority. He was not a dissenter in this case. And I've often wondered why not. And I have two things that occur to me. Number one, at one point, it wasn't in the presentation here, he had provided the state. His focus was on economics. He was big on if there was an impact on the state's economy, on the state's finances, then I think he felt that would have been sufficient reason to prohibit the tribes from doing what they were doing. And he threw the attorney for the state a softball question at one point. He said, doesn't the state get any revenue from these bingo games and poker games? Aren't the tribes taking these revenues away from the state? And the attorney for the state said, no, Your Honor, this is not about, they were sort of purists in this. They didn't want money to enter into this. This was purely a jurisdictional question. They said, no, Your Honor, there's no financial involvement in this case. This is strictly a legal issue. We think we've got the right to do this. And at that point, Rehnquist, I can remember this, Rehnquist sort of went, sort of sat back in his chair like, my God, I just gave you a softball and you blew it. So I think that had some bearing on it. The other thing is this, and I think this is probably more the case. After they conferenced, and they realized that there were only 3 dissenters, only 3 people were going to vote against the tribes. Rehnquist realized that even if he went the way he probably wanted to go, it would have been 5-4 in favor of the tribes. And in that instance, Justice Marshall would have been the one to assign the opinion. Here's how it works. The senior justice on the majority side gets to decide who writes the opinion. So if Rehnquist had been a dissenter, Justice Marshall, this huge supporter of tribes, would have been the one to decide who writes the opinion. And Rehnquist said, my God, what could he do with this? He could write something that undoes everything we've tried to do to limit tribes over the years. So I think Rehnquist decided as a practical matter, he was not going to dissent, and that allowed him to assign the opinion to Justice White, who was in the majority, but wasn't really a tremendous supporter of Indian tribes. And White wrote a very nice opinion. I love the opinion, but he could have said a lot more about it, but didn't. And I think had Marshall or Brennan written the opinion, it would have been probably better from the tribe's point of view. But by Rehnquist not dissenting, he was able to determine who would write the opinion. So that doesn't exactly answer your question, but I think it has a lot to do with how this opinion got assigned to Justice White.
That's really interesting. Thank you.
Sure.
Alex.
Thank you again for the presentation. I had a quick question, just looking at now from back then, that Supreme Court decision and talking about sort of the transition, there's other justices. How effective or how do you feel lawyers should go back and review some of these cases, just as the Cabazon case that we're reviewing? Like, I know there's certain issues going on in Florida that may go to the Supreme Court with their compact. So with this in mind and other states having this thing, how important is it for, I guess, us as students to go over these cases? And I guess because I know how difficult it is to explain to these justices that don't know about gaming or just any federal court judges,
Well, I don't think there's a single simple answer to that. The cases are obviously important, and at least in my opinion, the justices are trying to do the right thing, but they come at these issues from very different viewpoints, from very different backgrounds, and different perspectives. I think you have to rely on the precedents. But as I pointed out here, there are different precedents that support different positions. I mean, the state's view of how the Cabazon case should have been decided was 180 degrees different from our point of view. So what you have to do is find the precedents that support your position and explain why they are the ones that the court should use in its analysis, and at the same time demonstrate why the ones that that the other side is talking about aren't. I mean, the Colville case is a perfect example. The Colville case, the state is saying, this is the Colville case all over again. No reservation value, marketing exemption. Our position is it has nothing to do with Colville. We are we are providing reservation value. We had this whole discussion about all the services, the clean, well-lit facilities, and the court bought it. So, I mean, the court used that exact language in their opinion. So we were successful, and I think I would recommend to you, you've got to find a way to find the precedent support your position and the way in which to distinguish the precedents that go the other way. And the Colville case is a perfect example of how we were able to do that.
Well, appreciate that. Thanks for the feedback.
Sure. Anything else?
Well, it looks like we're at the end of the class period.
Oh, we are. Yeah. Okay.
Glenn, thank you so very much for doing this. Truly appreciate it. It really brings this case to life, and this case still is the lead case in this area. And I think it really helps cement the understanding of this case by you going through all of the different issues and providing some background for that as well. So thank you very, very much.
My pleasure. Thank you all very much for attending. So long.
Thank you.
Thank you.
Thank you. Bye.
Bye.
That was fantastic. Thanks.